Good evening and welcome to another edition of Tok Piksa. Tonight we talk about laws, national laws, and we speak to Dr. Eric Kwa, Secretary to the Constitutional Law Reform Commission, and Nanai Puka-Areni, who is the Director for Constitutional Law at the CLRC. Very welcome to Tok Piksa. Thank you for joining us. Dr. Kwa, we'll start with you. You're in a very important position in the country. You're looking at our laws. Where are PNG laws today? Are we on par with international standard? How much of work do we have to do?
Thank you, Neville. Let me say that we are in two different levels. Right. The first one is that we have got a lot of laws that we adopted at independence that are colonial laws. And so over the last 40 years, unfortunately, we have not done a lot of work to review and update those laws. Right. That's something that at the Constitutional Law Reform Commission we have started work on. We have started since 2012 to review all the pre-1975 laws. The idea is that we want to review them and see whether we could either update them or we will repeal them. A draft report has now been completed and we are ready to present it to the Minister for Justice to advise him on the next course of action to take in relation to those laws. The second thing is that we have also, since 1975, been formulating and drafting and passing laws in the last 40 years. And that's basically to keep pace with the current trends. In my view, unfortunately, these laws have been developed somewhat haphazardly. They have not been able to develop in a coherent, consistent manner. And that's because of maybe the lack of the participation by the Law Reform Commission. So what we have now done is that since 2011, we have now tried to address this issue of piecemeal approach to law reform. We are now suggesting to all state agencies and government departments to work closely with the Constitutional Law Reform Commission so that we can be able to take control of the law reform exercise. The reason is very simple. We want to ensure that the laws that are passed by different agencies are related to each other. There is a consistency of laws. The reform is done in a comprehensive manner so that we are able to properly maneuver this country towards the Vision 2050. We have now asked departments that we are aware of, or state agencies that we are aware of, who are reforming the laws. We're actually writing to them and we're partnering with them to help them to reform those laws. And taking that role, we have now realized that we are now able to inform these different agencies that we are working on this piece of legislation. This other group is already working on a piece of legislation, so there is this connectivity. We're hoping that over the next couple of years we will be able to entrench this mode of operation so that in the next couple of years we will see a holistic approach to law reform. And hopefully through this process we will also engage with the citizens a lot more in terms of the way forward on law reform exercise. At this point, I also would like to point out that at the Constitutional Law Reform Commission, we're also embarking on this exercise where we would now like to consolidate all the laws that have been passed by Parliament since 1986. Because there was a consolidation exercise that took place after 1975, and they consolidated all the laws into volumes that you would actually easily go and access. That consolidation is called the Revised Laws of Papua New Guinea. Now that stopped in 1986. We would like to now embark on this project so that anybody in Papua New Guinea can access a valid, authenticated law instead of picking it up from the internet, instead of picking it up from an agency that does not have the mandate to give the valid piece of legislation. The problem that we've seen over the last couple of years is that various people have different drafts or different versions of a particular law. We would like to try and help by ensuring that the laws that come out from a government source and maybe from the First Legislative Council or from us, that is the valid law. And you can pick up all the amendments. Because sometimes you will have the original copy of the law, but you wouldn't know the amendments that have taken place over the last 5 years or 6, 10 years. And you would be making reference to an old law that is an old section that might have been repealed already. And so that's something that we want to try and do, hopefully starting next year, so that any person from the street, any person from the world, anywhere in the world can write to us or can access our website, and they will easily pick up that authenticated law. All the revisions as well included. So that's something we're trying to do. But yes, Neville, that's very true. We've looked at the old colonial laws, and we are now in the process of, as I said, we're trying to update them or propose for their repeal. I'll give you an example, just for the viewers' sake, interest. We have an old law that was passed in 1953 called the Cemeteries Act. Now that law is there, but in today's situation, you find that people bury the dead wherever they want. But there is a law. There is a law that tells us that you cannot bury a dead, maybe next to the village, next to the river, or next to the house. Or there is a law. But who knows about this law? It's a colonial law. And so that's one law that we're trying to now review and see if we could maybe introduce a new one. And then there's an old law that is still on our law books that talks about the collection of copra. Long colonial time, also planting copra, so also planting coconuts. Now coconuts, planting lo paponing. So law come up sem, law 7 o'clock. Tractor no around lo road look sim coconuts lo night. So 7 o'clock tractor no around. But today you think the tractor stop lo night. But it's like law him stop. Law him to go sem no can put him light on na tractor on lo night na collect him copra. Now that's in 1930 something law, and that's still on our law books.
What do you do with that kind of a law? How would you change it, and what would be the reasons for changing it?
Well, what we will usually do is that we will review it and see the relevance of it to the current circumstances of Papua New Guinea. And then if we find that it's really not relevant at all, then we will propose to Parliament for the repeal of that law. Okay. A classic example is the law on sorcery. It's been a big controversy in Papua New Guinea now. People have asked us why we actually asked Parliament to repeal the Sorcery Act of 1971. And the reason is because we found that the Sorcery Act cannot be proven in a court of law. So the act of sorcery is very difficult to prove by law. We understand that by belief, yes, for spiritual purposes, yes, that is relevant. But for us as lawyers, judges, as government, trying to prove an act of sorcery, it's very difficult. So for example, if you're going to accuse somebody of puri-puri, then you say, oh, I had this Sosara uttering some words, and then calling the name of the sick person. And then immediately after that, a day later, this guy got sick. Now, how can you prove that in the court of law? I mean, how can you prove that utterance, that this is the words that was being uttered? Because those might be secret words. So if the witness is going to utter it, then the question is, will that witness also be placing cases on the guy who's now sick? How do you prove it? And where's the link between that word that is spoken and the person who is sick? We can't prove it in law. In court, we can't. And that's what the law actually was designed for, that we must prove it in court. Then we can convict the sorcerer. It's difficult. We have looked at the different cases since independence, and we have at the Supreme Court. The Supreme Court has also made some observations about this act, and the main conclusion is that we need to repeal it. And we stick by the law on assault. We stick by the law on murder, attempted murder, grievous bodily harm. Those acts of violence that are perpetrated on the victim, we must take them on the face as criminal offenses. Let's not use excuse, sorcery as an excuse. And so what we have also now done for the information of the viewers, the Constitutional Law Reform Commission has also worked with the government to now push for a new offense called sorcery-related killings, which will now carry the death penalty. That was passed in May last year. The government has now taken on but a different approach, that if you now accuse a person of committing sorcery and then you kill him or her, then you will now be yourself put to death. So sorcery-related killings is now a criminal offense. The whole idea is to stamp out this this phenomena of violence. Our report, our research have shown that the people who are actually accused are people who are in the vulnerable category. These are usually people who are helpless. In most cases, they will be the widows, they'll be the widowers, there'll be these very old women who are living by themselves, no relatives, no children. So the victims are usually the vulnerable persons. It's nothing to do with attacking the able person who is able to defend himself. It's not really the case. Evidence is very clear. The victims are always the weak ones. And that means that it's usually a case of randomly looking around the community, trying to place a blame on someone. And so our view is that we do not want to say that we don't think that sorcery is here. That is a belief. And how people believe in it or not, that's their own personal view. But by law, we cannot control something which is spiritual in nature. And that's what we did. So I thought I might just explain that to the viewers. So yeah,
well that brings, obviously human rights is what is behind the need for laws. And the fact about the life imprisonment, death penalty is an issue that we've been approaching in the past couple of years. You've been directly involved with laws on death penalty and conducting research in the area. What have you found out?
All right, that is a very touchy issue because we're talking about taking the lives of prisoners. Let me say prisoners. It's not taking the lives of people, but it's a taking of lives of prisoners. Prisoners who have been properly processed by law and have now been convicted by the courts, and the courts have made a decision that these people must be put to death. So my argument has always been that the parliament in its wisdom, it's not my wisdom, it's not people's wisdom, but the parliament, the leaders, they have considered the issues, and then they're trying to address a problem. And the problem is law and order. The problem is the prevalence of rampant violence in Papua New Guinea. And these are not just simple violence. These are sometimes very horrific, horrendous violence that are perpetrated on our people by a small group of people within our community. But by and large, because of the actions of these few people, they then bring in this description of our country as a very violent place, unsafe place. And so the government, as a responsible government, has to respond to that particular situation. And so in 2012, 13, they then amended the criminal code to now create a number of offenses which will now carry the death penalty. Now it must be made clear to people that death penalty was here before independence. It was on the law books. It's always been on the criminal code. And so the death penalty in law is not new to Papua New Guinea. It's been there since 1950s. And then a couple of our people have been hanged for certain offenses. The only difference is that at independence, we said the method of killing will be by hanging. And then we also said there will be a number of offenses that will not carry the death penalty. But in 1991, the parliament removed one of them, and that's willful murder. Before 1991, willful murder would be death penalty. In the last maybe 20, 30 years, we have now seen that the incidence of crime in Papua New Guinea has increased. And it's increased with very, very terrible level of violence. And so in 2013, the government said, okay, let's respond to this. And so they now have said a number of crimes will now attract a death penalty. I was there. We did discuss this. We did deliberate on this. And the government was very serious. So we need to respond to this. And so they went ahead and they passed some amendments to the criminal code to make now some of the offenses to carry the death penalty. The first one now that they've now included is the sorcery-related killings because of the increasing violence against innocent victims. So if you kill someone and you suspect that person of sorcery and you kill that person, you will now be charged under this new offense called sorcery-related killing. It will not be willful murder, it will be sorcery-related killing. And that will now attract a death penalty. So you'll be put to death. We have also now created the offense, the aggravated robbery, because we know that criminals who rob innocent victims, they then go ahead and either kill them or they actually cause them grievous bodily harm. We are now saying that aggravated robbery will now also attract a death penalty. We've also said rape of young girls under the age of 10 because they rape them and then they kill them. So they will now, the perpetrators will also be put to death. And then willful murder, put to death. And of course, the other law was on piracy. Piracy, you will be put to death. The other law that we were proposing, but the parliament has in its wisdom decided not to include a death penalty, is the misappropriation, stealing of public funds. The original plan was, the intention was to say that any person that misappropriated public funds to the value of 5,000 will be sent to life imprisonment. But that has now been increased to 10 million. So any person that misuses public funds to the value of 10 million will now be sent to prison for life without parole. Now the question was the method of killing. And so the idea was under the current law, before 2013, it was by hanging. But with the new law that they have now passed in May last year, they have now given 4 different methods of killing. So the first one is hanging. The second one is lethal injection with the deprivation of oxygen. The third one is lethal injection with anesthesia. So they will be given a little injection with anesthetic, and then that will basically kill them. The fourth method is by electrocution, and the fifth method is by firing squad. Now the government has been asked to consider and apply only one. And so at this stage, the government has not made a decision yet in terms of which method it will apply to kill the convicted prisoners. The issue of human rights arises in terms of the process by which a prisoner is then taken through the court process, and finally a decision on death is being imposed on him. That we must follow the human rights principles, and that's something that we now have taken into account, and we say that yes, the person must be properly arrested, charged, and prosecuted. He must be given the opportunity for legal defense. He must be given the opportunity to be heard by a court, and then if he is convicted in the national court, he's now got a right to appeal. And then after appeal, within 60 days, he must ask for clemency, power of mercy. So that's all in place. If those processes were not in place, then I would say there will be a gross violation of the human rights, because then we are now becoming the judge and the jury and the executioner at the same time. But the legal process is there. The other human rights issue was in relation to the method of killing. And so whether the firing squad will it affect the human rights? And the human rights is basically in relation to the right to the freedom from torture and inhuman treatment. So when you're shooting a prisoner, are you torturing him? Is that inhuman treatment? So that was the question. Or if you hang him, is that inhuman treatment? So those were the questions that we had to consider in terms of the 5 methods of execution. And as I said, the government now has to make a decision based on the report that we've now put before Cabinet on the best method to execute the prisoners. Now I've been asked and I've been challenged, so you are supposed to promote human rights, and why are you promoting death? And I'm saying there are 2 different things. Promotion of human rights, that will be the core function of our office, core function of every lawyer. That's our role. We must protect human rights. The moment the human rights process has been completed and the person has been properly, through the legal process, been sentenced to death, I cannot say that I'm promoting the violation of human rights. No, that's already been captured. Human rights have been followed. The person has now been put to death not by me, but by the courts. The courts have decided that this person must be put to death. The argument put forward by the Attorney General is that the court has made the decision, and every year that we do not implement the decision, the state is in contempt, because they must implement the court decision, just like every other court decision. When the court makes a decision, we must comply with the court decision. If we don't comply with the court decision, that means it's contempt. So the government's view is that the longer we keep these people in prisons, on death row, then we are in violation of the court order, because the court has already ordered that they must be put to death. And so it's no longer an issue of my own personal views or my own personal beliefs, because that's already now been given by somebody else. An independent adjudicator has now made a decision. And so all I'm saying is that, well, somebody's made a decision. Let's implement the decision. That's what I'm saying. So that's the fundamental difference that I thought I might bring across to the viewers. It's not that we want to put people to death. No, we are trying to address the issue of crime. And we have tried to look at it in different angles. The government is pumping a lot of money into the law and justice sector. We have tried to create a lot of opportunities for our young people, but still the prevalence of crime, violent crimes in Papua New Guinea, continues to grow every year. And so we need to tackle that. And from the government itself, they've responded to that. That's not my response, that's a response from government. What we did was that basically we went to give advice in terms of how they would manage that decision. To
so the final decision with the government now is to the method of implementing the death penalty. Yes. How long do you think we have to see something?
From discussions with my minister, the Minister for Justice, he said, well, the submission is already before Cabinet. Okay. It's only depends on the PM to basically bring it to the floor of cabinet. So reports have been done, everything has been put in place. We're just waiting for the Prime Minister to at least table it to be deliberated. And that's something that is left with the Prime Minister to deal with.
Very good.